Let's go share. We're going to start with the Molotov cocktail throwing lawyers. Washington Free Beacon, I appreciate it, might have a little political leaning to it. You know, you can identify spin and we can identify facts. It seems that these two individuals, lawyers who were arrested, convicted, or pleaded guilty to throwing a Molotov cocktail or attempting to at a police car. Well, while some people are having their charges upgraded, these individuals, after agreeing to a plea deal, there was a superseding indictment that apparently lowered the charges, and they're going to enter into a new plea deal with lesser sentencing than what they had already agreed to. But on the cusp of the nonstop, around-the-clock primetime coverage of January 6th committee, I will be covering that when it goes live on Thursday. A couple of DTs, that's what we're going to call it, DT, are actually getting their day in court, and it's informative to see how Merrick Garland's Justice Department is handling their prosecution. Oh my goodness, forget that. But listen to this. Collinford Mattis and Aruj Rahman were arrested in you can tell the political spin, ideological leaning, mostly peaceful protest following George Floyd's murder. And they're calling it murder now, by the way, interesting enough, because it went through a verdict and it was a murder and not merely a homicide. By judicial fact, it was a murder. Whether or not people agree with the verdict, that is now a factual statement, a factually accurate statement, as opposed to pulling a Whoopi Goldberg and calling Kyle Rittenhouse a murderer, even though he was acquitted. He committed an act of homicide, but not murder. Two legally distinct descriptions of arguably the same incident, one of which would be defamatory if false, and Kyle Rittenhouse is contemplating going after certain people for making those statements. And this would be factually correct given the nature of the verdict against Derek Chauvin. The two lawyers handed out Molotov cocktails to the crowd, and Rahman tossed one into a police car before fleeing the scene in Mattis's van. I want everyone to appreciate, I want you to compare this story to Brandon Strzok's story. Compare these facts to Brandon Strzok. I'm only saying this because it's relevant in a sense to him being an apostate. A gay man who considered himself to be a liberal, who got so disgusted by the liberal Democrat Party political entity, he walked away, started a movement called #WalkAway, became, I guess, a vocal supporter of conservatives and Donald Trump, was on the Capitol Hill on January 6th, on the steps of Capitol Hill, never breached the entrance, never went through the door, recorded for 8.5 minutes, no violence, no nothing, by all accounts, prosecuted, persecuted, arrested, detained for 2.5 days, released, pleaded guilty to a petty misdemeanor, 3 months house arrest, 3 years probation. Oh, I just spat all over my computer. Designated a 4S whatever for TSA. We went into it. Compare that treatment to these individuals who handed out a Molotov cocktail to a crowd. Rahman tossed one into a police car before fleeing the scene in Mattis's van. They reached a plea deal with federal prosecutors in October 2020 that wiped out 6 of the 7 charges against them. They wipe out 6 of the 7 charges by plea deal, whereas in the other cases, they start saying, we're going to throw on more and more to get you to plea to a petty misdemeanor where we're going to impose the maximum sanction in the court. These prosecutors nonetheless sought a maximum 10-year sentence and argued that the incident qualified for enhancement that would turbocharge sentencing, a determination with which the U.S. probation officer concurred. Ginning herself up to here we go. Okay, she gave an interview. Okay, you can read that while we do this. Mostly peaceful, though. Mostly peaceful. In mid-May, the same career Department of Justice prosecutor who argued for that 10-year sentence were back in court withdrawing their plea and entering a new one that allowed the defendants to cop to a lesser charge of conspiracy. It tosses out the Big T enhancement entirely. How convenient. I mean, it's not that there's corruption. It's like, it's not corruption any more than it's hypocrisy. It's just hierarchy. It's just pecking order based on politics. We can find charges when we want them. And we can forgive charges when we want to. It's over the top. I feel like it's over the top. Sorry, that's a very dramatic. Now I'm just gonna. Okay, but wait, there's more. I hope everyone gets that. But wait, there's more. I think there's more, actually. The new charge carries a 5-year maximum sentence, but the prosecutors are urging the judge to go below that, asking for just 18 to 24 months on account of the history and personal characteristics of the defendant. You know what? History and personal characteristics of the defendants, that's a euphemism for privilege. That literally, that is what people mean when they talk about privilege. Personal characteristics, history and personal, you mean like the absence of priors, a la Brandon Strzok? Or the personal characteristics, meaning they're lawyers, they have their whole futures ahead of them? That type of privilege? If you're a lawyer who throws a Molotov cocktail and then drives off the assailant, you get special treatment because you're a lawyer. But if you're a petty criminal, or you are, although none of the Jan 6 even did it, if you're a Jan 6, my goodness, are you going to jail for as long as conceivably possible? And the aberrational nature of the defendant's conduct, it was a crime of passion. They were so politically impassioned. Hashtag political permission slip. They were so politically impassioned. Let's make sure that my phone is on just in case I get a call. Because, you know, Matt, this is where you can see some spin. Mattis graduated from Princeton and New York University and was an attorney at the White Shoe law firm, Pryor Cashman. Oh my goodness, it's a law firm called Pryor Cashman? That's not possible. The Pryor Cashman. That is one heck of a name for a law firm. And Rahman was a public interest lawyer whose best friend, Obama, this is according to the article, but Obama administration intelligence officer guaranteed the $250,000 required to release her on bail. It's an unusual step, says James Trusty. A former prosecutor in the Department of Justice Criminal Division broke it down for us this way. This is the interesting, they've already agreed to the deal. Swapping in a softer plea agreement after having gone through the plea hearing is an exceedingly rare event in federal court. It can happen, he said, if there is truly some new development or understanding about the defendant that merits a fresh look. Yep. Anyhow, so that's it. That's the two-tier legal system, not just in the States, in Canada. You know, when they want to have a rehearing on bail conditions for Tamara Litch, the court says, yeah, we want a rehearing. We want to put her in jail because she posted a picture of her with a pendant that said what did it say? Freedom Convoy, Freedom Truckers. And just, you know, so here you got your homework so that everybody can trust this. You can take the article with a degree of skepticism. The government respectfully submits this letter to 1, notify the court that the parties have reached an alternative resolution of the charges in this case. 2, request that the court cancel the scheduled May 18, 2022 hearing on defendants' objections to the probation, yada, yada, yada. And 3, convert the May 18, 2022 guidelines hearing into a change of plea hearing. And 4, set a new briefing on the sentencing schedule at the change of plea hearing on May 18. The defendants join in the request for relief in this matter. Yeah, no crap. Please drop the DT charge because that's kind of a big deal. Withdraw or imagine this had been Michael Flynn, pleaded guilty to an actual crime and then withdraws his plea because that's effectively what they're doing right now, so that they can plead to a lesser charge. I'm reluctant to make the comparison because then people are going to say, well, if I thought it was wrong in the Flynn case, similarly, I have to think it's wrong here. Flynn withdrawing his guilty plea to a charge of lying to the FBI, given the nature of that charge and the actual factual basis of that charge, I have no problem with. In this case, given the actual charge and the actual evidence, that they get to undo their plea to that charge so they can agree to a lesser one because the Department of Justice had a change of heart, I got a problem with that. Because the facts, the underlying facts are radically different, as is the nature of the charge. But that's the latest. So these individuals who, you know, were facing serious time for serious charges, throwing a Molotov cocktail into a police officer's car. Yeah, that's not quite the same as lying to the FBI when Michael Flynn's lie to the FBI was not an overt lie by even the FBI's account. It was an equivocation as to his memory of a fact that the FBI knew because they had that fact in their hands on a transcript. He says, I don't recall, but you have the transcript. You should know. And they said, we don't believe you when you said you don't recall, lying to the FBI. In this case, throwing a Molotov cocktail into a police officer's car. I mean, political hypocrisy, a two-tiered system. And some people, Brendan Strzok, January 6th, what's his name? Jacob Angeli, QAnon shaman, in jail for 5 years. I think it's between 4 and 7 years, 4 and 6 years in jail because he entered the Capitol Hill and paraded and picketed with a flag apparently on a spear. These individuals are going to do less time than Jacob Angeli, if they do any.